Good morning. Today I wanted to take a few seconds and talk about a topic that I've been asked about many times over the years. And sometimes the answer has been a little bit gray. And today I'm going to be able to shed a little bit more light on it and discuss in a little more detail for residents here in Tennessee because of a recent court decision that has just come down from the Tennessee Supreme Court. So today we're going to be talking about the significance of posting private property, no trespassing signs on your property. Does that mean that people cannot come onto your property, or is it a waste of paper? Well, as of April 7th of this year, 2017, the Tennessee Supreme Court has ruled that effectively posting a no trespassing sign or a private property sign in and of itself does not remove your implied consent to allow people to come onto your property. It's a little bit confusing, the decision. They spent a lot of time discussing how there's a split among states about how they handle this, but the state of Tennessee has come down on the side to say that in and of itself, they say that a no trespassing sign is ambiguous. That is, it is not clear what message you are conveying to people when you post one of these, or three of these, or five of these on your property, whether or not that is clearly sending a message to people that they're not allowed to come onto your property without prior consent. I know there are a lot of people who are going to hear that and shake their heads. I think sometimes these are the kind of decisions that we make in the legal field that makes people shake their head at us and think that we've lost our minds. That the idea that posting a sign that says private property, no trespassing, is not a clear message for people not to come onto your property without prior permission. But the courts have decided otherwise. And if you want to read more information about it, the case is State of Tennessee versus James Robert Christensen Jr. Again, it was filed April 7, 2017, so it's very fresh. And in it, the court said that no trespassing signs, private property signs, in and of themselves do not convey the message that people are not welcome to come onto your property. In fact, they indicate in pretty clear language that to get to the point, the threshold where you're conveying this message clearly, you would need examples such as a fence around your property with the sign attached to it, a gate or some obstacle or obstruction in the driveway that would keep people from being able to come onto your property. That then they believe that it's not ambiguous, but by itself that it would be. In fact, they go so far as to say that, and I'm reading a quote here from the case, that when a sign says posted private property, hunting, fishing, trapping, or trespassing for any purpose is strictly forbidden and violators will be prosecuted. The court said that that was ambiguous and confusing and that the common person would not know what that meant. I don't know what to say about that. It seems pretty clear to me, but I'm not on the Supreme Court and I'm not making laws and I'm not interpreting them. I'm just passing along the information that according to the Supreme Court of Tennessee, that is an ambiguous statement and people would not know what that meant. So I don't know if there is such a sign that would be clear enough for the courts to believe that it is conveying a message to people not to come onto your property in and of itself. Perhaps a sign that says no trespassing, no entry, I'm expressly revoking any privilege for anyone under any circumstances to come onto my property without prior written consent, boldly displayed in the front of your property and the only way to come onto your property. Maybe that's enough. I don't know. I don't even know if that would be. I think the courts are clearly saying that the sign in and of itself is not enough, that you would have to put up a fence or a gate or some other means to convey a message more than just words, because according to the Tennessee Supreme Court, and other courts in other states as well have decided similar, and some have gone the other way, that no trespassing is not clear enough, neither is private property, keep out, neither is no hunting, no fishing, that those messages are not clear enough for people to understand. So again, as I often do through the Legally Relevant podcast, where we discuss about legally relevant news, in Tennessee and in the surrounding areas. Wanted to kind of bring this information out there because I'm often asked by friends of mine and colleagues and people through Facebook, if I put up a no trespassing sign, is that enough? How many do I need to post? Where do I need to post them? So I wanted to bring this information out there. And again, to know about your specific situation and how it might apply to your specific land, recommend if it's an issue that you want to be clear on, go and talk with an attorney who either specializes or practices in the area of land law or real estate law, and see if your particular circumstances meets what the court's recent decision is. Appreciate you tuning in. Have a great day.